Hello, my name is Merrilee Boyack. I am the Director of Development for Pro-Life Utah. And I'm here to talk to you today about my analysis or summary of the hearing this morning from the Utah State Supreme Court on the issue of the injunction granted on the elective abortion ban legislation that was passed. This hearing was held this morning, and the State Supreme Court was hearing an appeal from the Attorney General's office in order to overturn that injunction and allow the law to go into effect, which would ban elective abortions in the state of Utah and save many lives. So kind of some overview of the things that I observed. First of all, I was surprised at how much argument was done on the merits of the underlying case. I thought that they would really be focused on strictly whether or not the injunction was properly granted, but the hearing was very expansive in its scope in talking about abortion and the context of whether or not it was constitutional and so forth. One of the questions that was asked was in the interpretation of the Constitution of the state of Utah. This focused a great deal on the historical aspects of when the Constitution was signed, on whether or not the founders, anticipated creating a right of to abortion, or whether they wanted to continue to make it illegal. I thought the Attorney General's attorney's argument on that one was much stronger in showing that not only did the founders, believe that it should be illegal, but that they continued to uphold that position through case law developed all the way up until 1973 when Roe v. Wade was enacted. By contrast, the Planned Parenthood attorney was very I'll say overarching, broader, didn't have specific precedent, and just kept saying that if they'd only known that it would have been safe and effective and routine, that it would have been okay. I thought that argument was incredibly weak. There was also a lot of debate regarding the issue of standing. This is who has the right to sue. And there was some pushback on Planned Parenthood of why didn't you also include women who had been harmed and not just the organization? Because when you're looking at standing to sue, you have to also show that a harm has happened, that the plaintiff has been harmed in some way. So there was a great deal of debate about this harm issue. And I thought the Planned Parenthood argument that they would suffer this economic harm and that harm to their reputation, I thought that was downright laughable. In fact, one of the justices was pushed back and said, you think they'd blame it on Planned Parenthood that they couldn't do abortions anymore? I mean, I thought that was very weak and like I said, just kind of very amusing. And then, there was a comment on the fact that when the district judge, Judge Stone, granted that injunction, he talked about the serious concerns of the harm to women, but he did not mention at all, if I recall, the harm to the unborn. And so that was kind of brought to light as well of, we're having to balance here harm to the unborn to even exist. And I thought the Attorney General's attorney really did a good job of saying, their harm is irreparable. They will not even be able to live versus this, possible economic harm. And one justice pushed back on, there wouldn't be criminal harm to Planned Parenthood if they didn't break the law, which I thought was, an effective counterargument. The one concerning part of this is that the injunction was granted on what's called serious concerns. That was the standard that was used and was in law at that point. That has since changed in the last legislative session. They passed a law that the new standard is that the judge has to find that the plaintiff will, that there's a substantial likelihood that they will prevail on the merits. That's a very different standard. And so they talked about this judge using just serious concerns. And he talked about the serious concerns to the impact on women. once again, there was that question of, you're not suing with individual women, with them being plaintiffs, you're suing as this Planned Parenthood organization. So there was some talk about whether Planned Parenthood could be what's called a third-party representative, that they could argue on behalf of their patients, on behalf of other women. The attorney was very weak in her arguments on that, and so a couple of the justices kept trying to help her, basically by handing the argument to her and saying, I think what you mean to say is, and then just giving it to her. Overall, I will say this. I feel that the Attorney General's case on behalf of the state of Utah was outstanding. She was terrific. Clear, concise, articulate, had great precedent, cases that she was citing very clearly. I thought she answered the questions very well. Planned Parenthood's attorney, on the other hand, was weak, superficial, and was not really addressing the issues very seriously. When asked for precedent cases, often would say, I don't have any, over and over. And I thought, my gosh, how could you not have any? You have to have, you've known about this for a very long time. So I was very underwhelmed with her. However, I will say this, in cases like this, the bias of the judges was showing for a few of them. And that is what is concerning, that they will just take it and, rule the way they want to, right? That they will make the arguments themselves. But I do think that this was very thorough. I thought that the justices did a great job on asking good probing questions, good analysis. How this will turn out, we do not know. We do not know, but I am so proud of the Attorney General's office and their vigorous defense of the unborn. I will tell you one troubling thing that came out of this. The attorney for Planned Parenthood used a phrase that I have not heard, and she called abortion on several occasions safe, effective, and routine. That word was horrifying. When Roe v. Wade was first argued, and they kept arguing that abortion would be safe and rare. They wanted it to be safe, legal, and rare. They kept saying that. Now, we all know that it has not turned out that way. 73 million babies are killed through elective abortion in the world every year. 73 million. It is not rare. But now, in a day where they are calling it safe, effective, and routine, what has happened to our society? What has happened to the humanity of our society that a great legal argument is considered by saying that this horrible practice is routine? That was shocking and painful to hear. So I hope all of you will join us in praying that the Supreme Court will stand in the defense of babies, will stand for the rights of these babies to exist, and will do the right thing. Thank you.